Hello everyone, my name is Molly, and today I'm going to be discussing the insanity defense. First off, I want to talk about what the insanity defense is. To simply put, it is when someone claims to be insane or unstable at the time of his or her crime. In other words, it's someone who lacks the mental capacity to recognize the wrongfulness of their crime. And each state, they use a different rule to justify insanity. The first of those rules is called the McNaughton Rule. It is the oldest rule, and it was named after Daniel McNaughton in 1843. It states that a person at the time of committing his crime was laboring under such a defect of reason as not to know the nature and quality of the act he was doing, or if he did know it, that he did not know he was doing wrong. In other words, it's when someone commits an act, and they knew they committed the act, but they weren't aware that it was wrong, which is also why it's called the right from wrong test. The second rule is the irresistible impulse test, and it was developed as a supplement to the McNaughton Rule in 1897. It states that a person cannot be held liable for their crime because they cannot control their actions. In other words, their impulses control their thinking. The third rule is the Durham Rule, and it was named after Monte Durham in 1954. It states that an accused is not criminally responsible for his unlawful act if it was the product of mental disease or defect. It is one of the most controversial rules as it encompasses a broad range of mental illnesses, which is the reason for the development of the Model Penal Code as a modified version of the Durham Rule in 1972. This rule states if a criminal lacked the substantial capacity either to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law, he would not be held responsible. The last rule was the Comprehensive Crime Control Act, and it was signed by Ronald Reagan in 1984. It changed the federal rules on the insanity defense, and it stated one must prove they lack the capacity to appreciate the wrongfulness. Next, I'm going to be talking about the history of the insanity defense. It started off as a compromise between society and the law because the public did not feel safe with dangerous mentally ill people walking free. The first known recording of the insanity defense occurred in 1581, where in an English treaty it stated if a madman or natural fool or a lunatic in the time of his lunacy kills someone, they could not be held accountable. In other words, if they did not understand the crime, they were let off. By the 18th century, if a person was aware of his actions and knew the difference between right and wrong, they were not declared insane. If it was the opposite, they were. And then by the 19th century, it was a question of fact that left the jury to make the decision. And that's why in 1843, the first famous case involving the insanity defense occurred involving Daniel McNaughton, where the McNaughton Rule was developed. This was the first rule, and it changed quite a few times and was adapted as time progressed. And now there are 5 rules in total. Daniel McNaughton was the reason for the making of the McNaughton Rule. He was a paranoid schizophrenic who believed the British Prime Minister was conspiring against him, and so he went to go and kill him. Instead, he killed the British Prime Secretary, and at his trial, claimed to be delusional, and because of this, was acquitted by not guilty by reason of insanity. This verdict was the reason for stricter requirements for insanity defense in court. The current state of the insanity defense is divided into 5 different rules and applied differently in each state. There are 4 states that dismiss it entirely, and these include Kansas, Montana, Idaho, and Utah, while the remaining states use a combination of or only one particular rule. Those that are then convicted of this crime are placed in a mental institution. They can spend longer time in a mental institution than they would if they were sent to prison. And the reason for this is because they can only be released if someone in authority believes that they are no longer a threat to themselves or the community and that they have been rehabilitated. For example, a man by the name of Albert Fender committed quite a few brutal acts and was sent to a mental institution for 20 years. After 20 years, he went back to trial and claimed that he had been rehabilitated. After listening to many testimonies in his defense, he was released and later confirmed that he had been rehabilitated. Since its inception, the insanity defense has been involved in quite a few controversies. And the reason for this is probably because it is so hard to prove or even disprove. And also because a lot of people believe that criminals fabricate a mental illness in order to receive a less severe punishment. Also, a lot of people are skeptical that even mental illness exists. However, most who obtain the verdict are actually verifiably insane, and very few are acquitted of the defense unless they are insane. The first controversy I want to talk about is the McNaughton Rule, as discussed above. It was the first rule developed, and it involved controversy because it called for stricter guidelines for the insanity defense, which was the reason for the making of the rule. The second controversy I want to talk about is the Durham rule, and it's a very vague and indistinct rule. The reason for this is because it encompasses quite a few mental illnesses, including drug addiction, gambling, alcoholism, and many people who commit crimes believe that they blame their crimes on their mental illnesses. Now into the future. Mental illness occurs in the brain, so obviously the answers lie in the brain. However, the insanity defense is very difficult to prove, as there is not a lot of evidence to prove that one has mental illness, and the reason for their crime was because of mental illness. So that's why many people are excited about neuroscience, which is the study of the brain. However, the results vary, and it's not exact science, so some are worried it may make the outcome of the trial worse. On the flip side, other people believe it's a very exciting development, such as scientists and attorneys, who believe who are excited about the benefits it will have on the insanity defense cases. However, it's in the early stages and there are only a few studies. I got to interview a man by the name of George Parnham. He was a Houston defense attorney who has been involved in quite a few insanity defense cases. He also believes it is the toughest defense to present to a jury, for a couple of reasons. One of the first is because many people believe that it is a last-ditch effort, meaning attorneys use this defense as a way to get their clients acquitted, even if they're not insane. There's also the antagonistic view of mental illness and the belief that mental illness doesn't exist, whereas the prejudice against mentally ill people affect their time in court, and people don't even believe it exists, so how can you convince someone of something they don't even believe? There's also the archaic definition in Texas, where in Texas, if a person is using the insanity defense, they should not be aware that the crime they committed was wrong. However, George Parnham has had quite a few clients who were aware of the wrong they committed, but they lived in a world of delusions where in their world, the crime they committed made sense, but in our world, it did not. The word no is the hardest part of the defense, he believes. He has a 90% success rate, and he also sees a change in attitude towards mental illness occurring, and that people believe it actually exists, and that it plays a part in mentally ill people's crimes. What do I think of the insanity defense? Before starting this research, I was of a different opinion. I believe, like much of the public, that people who were acquitted with this defense used it in order to escape harsh punishment. I believed this was convenient for them and unjust for the people involved. However, after researching, my opinion changed, and that I can see that those who obtained the verdict by reason of insanity actually need mental health assistance and are actually verifiably insane. I was also able to gather more information regarding the processes and the steps used in order to prove insanity. Finally, I believe that those people should be punished according to their mental health, and that is what the insanity defense does. Thank you. That would conclude my presentation.
That was